welcome back to the podcast. So today we have another one in this series of litigation sucks. And when I say litigation sucks, litigation's painful and it's expensive, but sometimes it's necessary. But still, nobody wants to end up there intentionally. So we're talking about all the ways to prevent it. So today's topic is litigation sucks, how to prevent it as a commercial subcontractor. So let's first talk about which type of party I'm talking about. So when I talk about a commercial project, obviously that's non-residential, but if you are a commercial contractor that's hired directly by the owner, you're kind of very similar to the residential contractors. You can kind of go listen to that recording when I was talking about litigation sucks and how to prevent litigation for the residential contractor, because you have most of the control because you write the contract and then your owner is going to sign it, right? So that's where you have a lot of control. This episode is more for commercial subcontractors who are signing somebody else's contract, which is usually very one-sided, not to the sub's favor. So that's the audience I'm talking to today is commercial subcontractors when you are signing someone else's subcontract. So how can you prevent litigation? So I have to tell you, you don't have nearly as much control as the residential contractors or contractor where somebody is signing their contract, because you were given a contract that you have to sign if you want to go to work. And there's usually lots of dangerous things in there. If you want to know all of them, go check out Quit Getting Screwed, the book, which is available on Amazon, or Subcontractor Institute. Well, I teach all of the chapters in Quit Getting Screwed for free. Check that out if you want to know all of the stuff that are in there, and some, change orders and other things we've covered as topics already on the podcast. But you're given a contract. And so how can you prevent litigation? First off, take some time to understand what's in the contract and the risk of what you're signing, right? You don't have to negotiate it if you don't want to, but at least understand what you're signing. So that way, if you see things coming, you can plan better for things like a pay when paid clause that you might have to front the whole job and not get paid, so you can have some cash on hand before you decide to take the project that you're signing with a pay when paid clause, right? So really take some time to understand what's in the particular contract that you're signing, the ramifications of what that means. And so what my firm offers and what we offer, and you can have anybody do that's a construction litigator that's familiar with construction, is we do a contract review. We do it on a flat fee and a 5 business day turnaround. You can contact me more if you're interested in that. But the whole purpose is that we're going to walk you through basically issue by issue, paragraph by paragraph, and tell you what it means, right? What a pay when paid clause means, what, the warranty provision looks like, when it actually starts, and is it extended by the prime contract? What does the contract mean? And so just off the bat, you're 100 times better than everybody else that just signs it, right? Because you know the risks that are in there and you understand what you're signing. Now, once you know what's in there, you can kind of decide what things are worth trying to negotiate and not. And I know that there's really not a whole lot of room for negotiation in commercial subcontracts. And you want to know why? It's because nobody does it. If you would all start negotiating contracts, it would become the norm, and we could make some headway on these one-sided commercial subcontracts. So try to negotiate it. So, and that's the thing, is you go through the contract, you figure out what the risks are, you figure out the risks that you really can't take as a business owner, right? Whatever that is. And we figure out a way, and we go back and we try to negotiate it. Okay, so again, we don't have a lot of control. Usually there's some people that won't negotiate at all. I'd be very leery of working with somebody that doesn't want to negotiate a contract at all. It kind of tells you what you're walking into. There's no room for any negotiation on anything. So, but if you go through the contract, you understand what it says, you understand the risk that it's taking, and you find hey, I'm not willing to do this job because this is too big of a risk for my company. Okay, so let's talk about negotiation. How does that happen? And so negotiation, especially in this situation, it's not like, no, I'm not signing this. No, I'm just going to cross this out, right? No, it's, okay, here's this provision. Here's what it means and the risk you're asking my company to take. I can't take that risk. Here's how we can meet in the middle, right? I find most negotiations, especially in this particular area of commercial subcontracts, you'll get more tractions if you can explain why you can't take that risk and provide another alternative that's somewhere in the middle. Not they take 100% of the risk, but not you take 100% of the risk either. So you come at it with, let's meet in the middle, and here's why, and really get them to understand. And the other part you have that you're dealing with this too is like the PM or whoever you're sending you the contract and asking for it back, right? Doesn't understand the risk they're asking you to take in that contract. So that's what you have to go and explain. Hey, this is what this means, and so they can run it up the flagpole and say, hey, this is kind of unreasonable that we're asking this company to do this. But if you don't explain to them what it means, they don't know. Don't assume that the other side who's sending you the contract knows what it says or knows what it means, because their lawyers have done it, or it's the contract they've always used, and they have no idea that the risk that you're asking to take. But these contracts have gotten so one-sided because everybody just signed them. So, especially right now with subs having the upper hand because there's not a whole lot of people to do the work, and especially good subs. So you can kind of push back and, call your shot. Hey, if you want me to work for you, this is my terms, right? This is what I'm willing to do. If you can't do it, that's fine. There's somebody else. And you got to take the two from the perspective of, if it's going to cost you to have a customer, then you're better off staying at home and sitting on the couch, right? The whole name of the game is you're in this to make money, right? I had a client yesterday who has a lien on a project for $384,000, which is his retainage and his last and some change orders, and they're offering to pay him $284,000. That they're taking off $100,000 for what? They're trying to, just trying to negotiate the amount he's owed. If he agrees to that, he's going to lose money on the job. That means he literally paid the general contractor to go to work. I would rather not do that. Why would you do that? All the stress and all the bullshit that goes with running a job, and at the end of the day, you're going to end up paying them for the opportunity to do that? No. And in this situation, he didn't have to. He didn't do anything wrong. So really take an evaluation of the risk that you're going to take. What kind of profit are you talking about? Is it really worth taking the risk? If it's not, I'm telling you guys, if we all start pushing back, we can make some headway, and negotiations will have to happen. If they want to get work done, negotiations will have to happen. So you're not only helping yourself when you do negotiations, you're helping the rest of the trades make this more common and make some headway on changing the standard bullshit that's in these contracts. But this is something I feel very passionate about, and nobody's saying anything about all the bullshit that's in those contracts. So I am, and we need to change them. And so that's one of the ways we can. So reducing the risk of litigation, understanding what's in the contract, understanding what you're required to do as far as submittals, pay application, change order, just the technicals, and all the other risks too. If you can abide by the contract, you're a lot less likely to get in trouble and end up in litigation. And try the negotiation skills, the way I can help you. If you need ideas on language or ideas on how to meet in the middle, I have some good ideas on that. I'm a great problem solver. So understand the risk, try to negotiate the risk that you cannot take. The other way my commercial contractors usually end up in litigation is for non-payment. Obviously, there's not a whole lot you can do about somebody not paying you, but what I'm about to tell you are the ways you can limit the non-payment from being a risk. First thing, read the contract and understand what is required to submit a pay application, and have that already beforehand on the first, because every contract, every GC is a little different. Are they using a platform? What forms do they want you to fill out? Make sure you have that whole packet correct, because obviously if you don't submit your pay applet correct and it gets kicked back, you're now going to be in the next group of pay apps to get paid. And that's really on you. So you need to take some and make sure, take some responsibility and make sure you've read the contract, see everything that needs to be, is your proof of insurance, all of that stuff, that your lien waivers, is all of that, everything that they require filled out and ready to go, and you filled out the pay app correctly, have somebody double check it for you. So that's the first thing. The way you can limit litigation for non-payment is filling out the paperwork correctly, including the pay application. The second thing, and just as important, is what are the lien rights in the state where you're working? Where are the lien rights in the state or the project is located? And knowing that up front, because there are several states that require you to send a pre-lien notice or a notice that says, hey, I'm working on this job. If I'm not going to get paid, I'm going to file a lien, right? It's before you're even owed money. Usually it's within 15 to 30 days of first work, you got to send a notice or you got to register with a lien agent. It really just depends on the state. And make sure you take that step so that if you don't get paid, you can file a lien. But once you take that step, especially in the states that require that, general contractors know you know your lien rights. And so if there's some, if there is a option between paying you and somebody that doesn't know their lien rights, they're going to pay you, right? Or you're going to get moved to the top of the food chain because you know your lien rights and you're going to follow the steps to have a perfected lien, right? And make sure we find out what those steps are before you even start a project, and make sure that we are in line to follow them if you're not paid, because filing a lien isn't litigation. And really the whole purpose of the lien is to, obviously it's leverage to get you paid because you're going to file a lien against the owner's property, right? To cover the cost of the labor and material that you're owed, right? And so they either have to bond around it, or they can't, get a loan, they can't go to permanent financing, or they can't sell the property. So lien is huge leverage, right? And so all states have different notices. You can always send notice early. You can't send it late. So if you know that there's an issue going on, that you have payment problems, send an intent to lien notice. Have your supplier send an intent to lien notice. That's another way that you can get out of being the bad guy. Hey, you don't pay me on my time. My supplier files their lien notices. They're on top of it. You're going to get a notice from them, and so is your owner. So that's a great way to prevent non-payments. Sometimes it can't be helped. The lien has to be filed, and a lawsuit to enforce that lien has to be filed in order to get you paid. And even to have that right, you have to make sure you know how to do it correctly. It's different in all states. Subcontractorinstitute.com has the rules for all 50 states on there. If there's some particular state you want to talk about, I have plenty of guests back and attorneys from other states talking about what they need to do to have liens perfected in their state. Go back and listen to some of those episodes. Knowing that on the front end and taking those steps will reduce the possibility of litigation, because getting a lien will get you paid, right? Obviously, the hope is not to file a lien. The hope is not to end up in litigation, but it is also protecting your rights. And most of the time, we can collect a file before the lien is filed or after the lien is filed without filing litigation. But if you don't take those steps and you don't perfect your rights, then you don't have a lien claim, and then you're almost 100% certainly going to have to sue the general contractor to get paid. And that is expensive and time-consuming litigation, right? So to wrap it all up, as a commercial subcontractor, you don't have a lot of control, but here are some things that you can do to prevent litigation. Number one, take some time to understand the risk of the contract that you're signing, whether or not you negotiate it. Understand what you're signing and how to maybe prepare for those risks. Second, if there are risks that you cannot take, try to negotiate. Like I said, how to negotiate, tell them why you can't take this risk, and offer some other solution that's in the middle, right? And then third, submit your payout correctly with all the correct paperwork on time. And then fourth, know your lien rights for the state that you're working in, and make sure you follow and send timely notice to perfect your lien rights. That is some of the best ideas I can give you as how to prevent litigation as a commercial subcontract. Guys, please like this episode and share it if you think somebody else would find it helpful. If you have specific questions, please feel free to reach out. I'm on social media. I'm on Facebook. You can send me the message there, or my email address. Let me know what specific questions you have. So I appreciate the time, guys. Thanks.